All right, we have done our part as members of the transport panel, so I'll wait for members to be seated and we can proceed with the briefing. Well, today I'd like to start by explaining the scope of our holistic review of the Waterworks Ordinance and the Waterworks regulations. In short, we'll examine the roles, involvements, and responsibilities of relevant parties, including the developers, contractors, and other persons who are involved in the design, construction, and maintenance of plumbing systems, including the relevant penalties. In this review, we also examine the registration regime for parties involved, and we'll also review the whole process on design, construction, and approval of plumbing systems. And I think one thing close to the heart of members is to review the plumbing materials. As far as this exercise is concerned, we wish to highlight the problem that in the past, plumbing workers would also assist the licensed plumbers in the plumbing works, and it has been the policy intent and the industry practice over the past decades. However, the current provision in the Waterworks Ordinance does not reflect the policy intent and the industry practice. Also, the Commission of Inquiry into Excess Lead found in drinking water recommended in this report that in relation to the relevant provisions of the Construction Workers Registration Ordinance Cap 583 CWRO, workers registered thereunder can also perform plumbing installations. So regarding this amendment bill, we are going to amend the main provisions such that these plumbing workers may also be authorized to carry out plumbing works. And we'll also set out clearly the obligations of licensed plumbers and plumbing workers. And we're also going to stipulate that all applications must be made by licensed plumbers. And then we set out here who can take part in plumbing works. I won't repeat the points. I think that in a moment when you examine the bill, you will learn more about the details. Now, as the amendment will allow more plumbing workers to carry out plumbing works, we need to make sure that these workers carry out works in the relevant sites, and therefore the Water Authority will be given the power to conduct inspections. As far as the offences are concerned, the time limit is that prosecution must be brought within 6 months from the date on which the offence is discovered. And we've also set up a consultative group comprising representatives from professional bodies, plumbing trade associations, plumbers association, workers union, construction sector, developers, etc. and they support the proposal in general. And we've also conducted 2 public consultation sessions. We have received views from the public, and our amendment exercise has already incorporated their views. We also consulted the Legco's panel on development, and basically panel members support our amendment bill. So that concludes my presentation, Chairman. So I'll open the floor for members to ask questions. Dr. Helena Wong. We do not have many members, and we have a lot of time, so I'll give each member 6 minutes.
Thank you, Chairman, for being the chairman. Because this bill is, the ordinance itself is very outdated. It dates back to decades ago, and we can see some flaws in the ordinance, like what you just mentioned. If we do not make any amendments, then for buildings built long ago, we can't take any action now, even if we discover any problems there. So I do support the amendment. The whole thing was caused by public concern about safety of drinking water because of the discovery of excessive lead. The Democratic Party always says that we should have a safe water ordinance. And the current laws are outdated, and the current regulatory framework is not adequate. The Waterworks Amendment Bill 2017 is not the same as what we have in mind. This is just a part of the Consumption Water Safety Ordinance, because this part only deals with the water parts. Water meters, buttons, welding materials, and so forth. Mr. Mack, right? Yes? You're nodding your head? So the excessive lead in water incident is such that the welding materials used for pipes were contaminated. So if the water parts are contaminated, the water will be affected. And the way of connecting the pipes, if the welding materials are contaminated, then the water will be contaminated. So we know that this bill is just a part of the pie. So I'd like to ask you, right now, this bill is talking about the responsibilities of LP, licensed plumbers. But in page 2 of your PowerPoint, as mentioned in the Commission's report, you have to delineate the responsibility of various parties. But in the bill itself, the parts suppliers, what about their responsibilities? It seems like the bill have not stipulated what their responsibilities are. You are now regulating licensed plumbers and workers, plumbing workers, people who work at construction sites. I'm sure there's a need for regulation on them, because if they don't have adequate training, and if they don't know enough about the issue, like some senior officials, then the water will be at risk. But the water parts may not be bought by the LP or the workers. They could be bought by the contractors, or bought under the instruction of the developers. So who would be held responsible for getting the parts? And also the suppliers, the trade associations, they may not follow the BS standards. They may have sourced some contaminated materials that could emit all sorts of toxic substances. So would the government allow these traders to continue to source such materials, even if there's a regulatory framework that they need to get your consent? But are you going to the construction sites 24 hours to check on their stock? I'd like to ask about the suppliers of water parts and the contractors and the trade associations. I mean, people who engage in trading of various parts. If they buy substandard materials, are there any sorts of regulations in this bill? Thank you, Dr. Wong, for your question. Dr. Wong is right in saying that this amendment bill itself mainly covers workers. And just then, when Mr. was taking you through the PowerPoint, our next stage of work covers various aspects, one of which is that we should review and strengthen the regulation of water parts. We will, after discussion with the trade, come up with a plan to seek your approval. And right now, under the Waterworks ordinance, if a plumber uses substandard materials, that already constitutes an offense. But of course, the standard requirements for parts, well, they need to be updated. So you may understand that we do have a subsidiary legislation which will be submitted to LegCo governing the standards of updating of water parts. But in the long run, at the next stage of work, in terms of legislative amendment, we will bring in some measures, such as codes of practice, to try to set out standards for water parts. Just then, Dr. Wong talks about how are we going to do with the suppliers. Well, not all water parts are used for drinking water. Like in the garden, the hose, that actually is used to water the plants, the water used there would not be of the same standard as drinking water. So what we need to do is to differentiate between water parts used for drinking water and those that are not for drinking water. So we're still discussing with the trade and see what sorts of options we can go for. If there's a better option like labeling, then that could be easy for the public to distinguish. For example, for drinking tap, what sorts of parts are of standard or up to standard. So we are now still discussing, and we haven't come to any consensus yet. Therefore, at the next stage of work, we will work on that. Right now, today, what we're talking about will be regulation of workers. But in your next stage of work, when will you deal with the water parts? Because if you don't let the workers use, that's fine. But what about, you can't continue to let people sell substandard parts. So indeed, you should do that in parallel. I don't understand why you deal with workers first and not take action against associations, trade associations. Mr. Mack, it's not that we're not doing our work now. We're actually carrying out the work in parallel, various types of work in parallel, and carrying out different reviews. But it's just that after this just because this amendment bill is now ready for scrutiny, that's why we have submitted it to you. But for other parts of our work, we are still carrying out consultation. As for the way ahead and what will be acceptable to the sector, we're still in discussion with them. As Dr. Wong, we are still trying to get things done ASAP because we do want to see amendments to the ordinance as soon as possible. Whatever part of our work is finished, is ready, then we'll come to you. Mr. Mack, can you tell us that of the 4 parts, you haven't done that in the bill? The 4 parts, are they all not covered in the latest amendment? Yeah, they're not included in the amendment. We're still working on the parts, but we've not come to a stage where we can propose amendments yet. Mr. Mack, I think we're all concerned about this issue because in page 2 of your PowerPoints, you mentioned that there should be an overall review. Can you explain more clearly, in terms of your point on the holistic review? For example, you will carry out amendments, or for some areas you would introduce new regulations, or for some other areas you might want to bring in terms of management of parts, to bring in good codes of practice and so forth, or through the use of a charter. So my understanding is that right now, it's not that you have got plans for all of these areas, but is my understanding correct? But can you make it clear for us that is today, the Waterworks Amendment Bill 2017 put before us today only covers part of the areas, but for other related areas in terms of water quality, you are still carrying out your work and will submit your plans to us over time. It will be best if you can give us a timetable. I know you're still discussing with the trade and considering various options. I know you may not be able to give us concrete dates now, but for various elements of the review and your stages of work, I know they differ, but can you give us a clearer explanation or give us a paper explaining your progress of work? Mr. Mack, okay, if needed, I can give you a plain paper to explain, but what I'm saying is that there are various aspects of our work. The first part is the amendment bill that is covering the workers' issue. There is an urgency for this because right now, under the current ordinance, the way that it's written gives us the impression that if it's not an LP or if it's a worker doing waterworks, and that's an offense. But that's not our policy intent. Therefore, we see an urgency to make an amendment now. Okay, other works that we are working on now, because the Waterworks Ordinance does not cover other parties like contractors, professionals, and so forth. It only mentions LPs. But indeed, within the construction sector, from the construction design perspective, there are various stakeholders involved. And we are discussing with them how we can delineate clearly their roles, duties, and to incorporate them into our ordinance and see whether we need to regulate certain types of construction works, stipulating that only certain types of qualified contractors can be involved. So we're still in discussion with the sector. Dr. Wong is very concerned about water pipes, the parts, the quality of parts and the regulation of them under current ordinance is written in such a way that this area will be covered by the subsidiary legislation, but that's not an ideal situation. In the long run, as we are discussing with the trade, we hope to bring in a code of practice to set out our latest requirements for water parts, the quality of water parts used. We think that that is a better approach. But to get that done, we need to come up with more lengthy amendment, legislative amendment. So we're discussing again with the trade and see how best we can do the amendments. And at the meantime, we will strengthen our requirements or regulations for water parts to ensure that when the parts are used for drinking water facilities, they are up to a certain standard. As I just said, so we are, of course, having various talks with the trade on various options, but we haven't come to any decision yet. So when the time is right, we'll come back to Legislative to brief you and make proposals to you. We are also thinking about, as Dr. Wong mentioned, the drinking water safety law. for the government in implementing a drinking water safety law, we have an open attitude. We are studying it, but basically, we hope that we want to actually implement a better system first for drinking water, and drinking water safety law is just part of that system. But just then Dr. Wong said that besides the safety law, other aspects also need to be strengthened. So that includes the amendment bill put before you today, the Waterworks Amendment Bill. As I just said, so we are actually doing various things at the same time, not one after another, but we are doing several things in parallel. So when the time is right, we will come back to Legislative to suggest amendments. I hope that my simple response can really address the concern. If not, we can give you a written paper later on.
不如係即係時間都講得比較多啦，就或者我。
Well, let me just clarify one simple point. You mentioned just now that this amendment seeks to clarify the obligations of licensed plumbers and plumbing workers, whereas for the responsibilities of developers and contractors, they're not covered. Do you mean to say that, say, later there will be a Waterworks Amendment Bill 2018 covering the obligations of these parties? Right, but I'm not suggesting that definitely it will be 2018. Next, Mr. Poon Siu Ping. As I mentioned just now, each member will be given 6 minutes. Well, I'll be flexible. Maybe there are issues that you're concerned with. I'll give you more time for that. I'm sorry, I want to know which position I am in the queue. The 5th. Well, we have a number of members not present at the moment. Well, because I need to attend another meeting. Now, let me read it out. We have Mr. Leung Chi Chang, Poon Siu Ping, Dr. Kwok Ka-ki, Edward Yu, and Ms. Alice Mack, and Dr. Helena Wong has indicated that she'd like to wait for the second round. But I raised my hand with Mr. Poon Siu Ping at the same time. Why would I be put at the back of the list? All right, if you're in a hurry, then I'll let you speak first. I need to speak because it affects workers. As Dr. Wong mentioned just now, you need to review other aspects of the ordinance. But it seems that you're proceeding with the part relating to workers first. So workers are very concerned about this. You mentioned that, first of all, plumbing workers would be able to carry out plumbing works, and this is good news, but at the same time, plumbing workers are concerned about this. And that is, although they can carry out plumbing works, they may also be liable for any prosecution, and they're concerned because they act in accordance with the instructions of the supervisor, and if criminal liability is attracted, then that's a concern. Honestly, they earn wages on a daily basis, and they don't work for any particular employer in the long term, and they won't need to commit any offense just to please the boss. But still, plumbing workers are concerned because they don't know what materials will be given by the employers, and then they would be liable. For any prosecution. And at the moment, there is a shortage of manpower in the construction industry, and for general construction workers, they may switch from one field to another, bar fixing or concrete, whereas for the plumbing industry, by having this new requirement, you may deter young people from joining the industry. So you need to explain the penalties and the defense available so as to reassure workers that they will not be prosecuted indiscriminately. Thank you, Ms. Mack, for your question. I'd like to clarify that under the existing ordinance, any person using materials not complying with the relevant standards will be committing an offense. And regarding this amendment bill, we're exactly addressing Ms. Alice Mack's concern. We have provided a statutory defense that the party can rely on, unlike the present provision, which constitute a strict liability offense. This amendment bill contains a statutory defense provision. As far as the worker is concerned, our objective is simple. If the worker hasn't deliberately used substandard materials, then the statutory defense will be available to him. That is to say, if he knowingly uses materials that are not up to standard, then he will be prosecuted. Whereas in the other scenario, if he only listened to the instruction of his boss, or say, for example, if the wrong material has been used in the plumbing installations, but if the worker has been told by his employer that the materials were up to standard, then the worker will be protected by the statutory defense. We need to prove that the worker has deliberately lied about that before we would prosecute him. So that means with the amendment put in place, a greater degree of protection will be given to workers. At present, it is a strict liability offense. As long as the wrong materials are used, the worker will be breaking the law. So in the future, workers will be given more protection. I think workers are very concerned because in the lead in water incident, there was a suggestion that some workers replace materials with the substandard ones for resale. And like I explained just now, the workers tend to hop from one site to another and they don't really work permanently in one site. So workers will not deliberately buy leather materials and replace them with the good materials, so to speak. So let's say if the boss has told them that the materials are fine, or just like what happened in the lead in water incident, somebody blamed the workers for substituting the materials, and that's the concern of workers. If it goes this way, then you deter young people from joining the plumbing industry. They would rather work in other fields instead. Mr. Mack, thank you for your question. We understand the workers' concerns, and that is why we have provided the statutory defense in this amendment bill. We have not impose additional liability on workers because in other pieces of legislation and subsidiary legislation, workers also are subject to the same standard. The focus is on knowingly and with intent. And if a worker knowingly uses the wrong materials, then he should be prosecuted. Whereas if the worker has no idea that the materials used are not up to standard, probably because the boss or the instructor has told him that those are the right materials, then he would be fined. We need to prove that the worker is lying and that he has knowingly used the raw materials. before we could prosecute the worker. Because there are cases in which workers knowingly use the wrong materials and affect the drinking water supply system, which may affect the public. So we've struck a balance. Well, you should know very well that workers will not deliberately and knowingly do something like that. Please give me some supplementary information. Explain clearly how you can reassure workers and address their concerns. Because very often if something goes wrong, the boss would say that they have given the workers the right materials and that it was the workers who substituted the right ones with the wrong ones. So you need to allay the concerns. I think Deputy Secretary already explained. But I think we need to carefully examine the provisions in this amendment bill to see whether those concerns can really be allayed. Ms. Alice Mack has already expressed her concern, and perhaps you can submit another paper to explain more clearly, especially how the amendment provisions can address the concerns, because in the construction process, many parties are involved, and those who commit the offense with knowledge should be prosecuted, whereas in other scenarios like the one mentioned by Ms. Alice Mack, please submit a supplementary paper to explain to us how the concern can be allayed. Mr. Peng Siu Ping. Of course, we all agree that safe drinking water is important. And about Ms. Alice Mack's concern, I share her concern, because although, according to the paper, you've consulted the industry, including the workers' union, well, I also got in touch with some workers, and it seems that they don't really understand the impact of this amendment bill on them. I understand that the plumbers would, on average, deal with 40 to 50 water meters a year. And a permit must be given by the water authority because before the water supply system is completed. I want to know how long it usually takes. It doesn't seem to have any stipulated time frame at the moment. And also, if the plumbing worker commits an offense, from the paper I learned that the prosecution must be initiated within a period of 6 months. So does it mean that the time bar is set at 6 months, and that if the construction is completed more than 6 months ago, the worker will not be prosecuted? Well, I understand that we're going to hold a public hearing. I want to invite the plumbing workers to express their views as much as possible to allay their concerns. Now, the administration has tabled the bill. I want more details on your consultation exercise. Let me first respond to the point about the 6-month time bar, and then I will invite Mr. Ng to respond to your other two questions. At present, if a breach is found and that prosecution is to be initiated, then prosecution must be initiated within 6 months of discovery of the offense, and we may not be able to do so. And we do have many such examples in which we fail to prosecute the offender because of the 6-month time bar. So we'd like to step up regulation through this amendment bill, and that is to say, is 6 months from the discovery of the offense. If we're unable to gather sufficient evidence within 6 months, then we cannot prosecute the offender. Now, once the defense is discovered, once we have gathered sufficient evidence, we must instigate prosecution within 6 months, or we cannot prosecute out of time. But now the requirement is from discovery of the offense. So I hope that I have addressed Mr. Poon question. As for the other two questions, I will invite Mr. Ng to respond. Thank you, Chairman. Thank you, Mr. Poon, for your questions. In applying for a water meter, it normally takes us 30 days to approve an application. But very often, we also need to consider the quality of application, so to speak. Sometimes there may not be sufficient information provided in the application form. And as a result, it may take more than 30 days to approve the application. Depending on the circumstances, if we have sufficient information needed for approving the application, we may do it within 30 days. Some members may have learned about cases in which it took more than 30 days, and we need to analyze the reason for that.
As for the consultation, there are several stages. Even before we set up the framework for the amendment, we actually had discussed with relevant parties. Well, in this case, it's mainly workers, so we've consulted the Hong Kong LP Association and also Association of Plumbing Workers. We told them about the direction of the amendment. And also, since then, we've set up a review committee comprising not just LPs and people in the trade. The committee also includes people from the architectural sector and developers and other stakeholders. At the third stage, we had an open consultation. We printed some consultative documents which were distributed to people, and they are available at district offices and also given to relevant parties. We asked them to express their views. At the fourth stage, we held a public hearing. Actually, they were held twice. One in Mongkok at the district office there, and the other was held in Hong Kong side at the center in the a town hall for the public to express their views. On both occasions, we received quite a lot of opinions, and we've incorporated their opinions into the drafting of the amendment. You also consulted our development panel. Yes, right. Yes, the development panel was consulted on January 24th. We proposed a paper to it. Yes, in theory, for LP, you have figures on the number of LPs. Have you all written letters to them informing them of the legislative amendment and that you are going to have consultation? Yes, through our consultative team, we disseminated the information to them. But it's not that each LP has the plan in the hand, because at the early stage when we worked on the proposal, we were still working on it, and we didn't have a complete version until we've drafted the amendment bill. And this amendment bill actually was finished quite late, like near when we came to LegCo, shortly before we came to LegCo. So you have various consultation channels, and Did you inform individual LPs? You have a list of them, right? You have sent letters to them, right? Informing them of the constitutive meetings. Did you invite them all to attend, Mr. Ng? Of course, LPs are one unit, and the biggest impact indeed will be on the plumbing workers. So therefore, we did not just let the LPs know of our plan alone. We indeed concentrated on communicating with plumbing workers. Okay, next one, Kwakaki. Chairman, I find that this ordinance, you have to, of course, endorse the amendments, but definitely this ordinance is not fair. You saw that what caused the leaded water incident, the culprit was the developers like China Construction. They made the decisions on the construction costs and the parts used, and the contractors were not aware of all the details. And many of the assembled parts were made in China, and there's no monitoring of them at all. And now, ultimately, the amendment put before us actually is done in such a way that people at the bottom of the workflow, that is the plumbing workers, are held responsible. And the Commission report suggests that we should examine the roles and responsibilities of relevant parties, including developers, contractors, and so forth. But what about that? What is being done to address that? You have not got any timetable, and you have no undertaking to really examine the roles. And now that you've given us the amendment bill, if it's passed, then what will happen afterwards? And also, you can see from the leaded water incident that people, actually the LPs, well, they try to actually they had to shoulder the bulk of the responsibilities, but the contractors made all the profits, and the LPs were only compelled to sign documents to get their work done, but the developers are the ones who profit the most. So when can you tell me you will give me an amendment bill that will hold developers, contractors liable legally? And also, I can't see how, with the amendment, water quality can be ensured. I'm sure you don't need me to teach you. Director of Water Service or Supplies Department would know. In the UK, they have an ordinance monitoring water quality. If anyone is found or an official is found to have failed to ensure water quality, he will be held responsible. So now you are just putting the people at the bottom of the rank bearing the full cost. You have to make sure that the water quality is up to standard, but there's no guarantee now under the current amendment. So that is now with the leaded water incident, and you're just trying to get some sort of solutions, and yet the situation would remain unchanged. You might arrest people in the front line to be the scapegoats, but they were just workers. The contractors who actually are given projects worth tens of millions of dollars can get away with it all. Well, you show us in your PowerPoints what you're going to do, but can you tell me when you will hold people who decide on the project costs responsible? And secondly, the water quality. How can you, through the law, ensure water quality? When can that be done? What sort of amendments would you be able to submit to us on that? Kwakaki? Just then, Dr. Helena Wong asked similar questions, but I can get the administration to respond as well. But let me remind you, I think can you give them time? In page 2 of the PowerPoints, they explain that what we're asked to do today, the amendment bill, only solves part of the problem. He said they acknowledged that, and they can give us a supplementary paper on their other stages of work. For For some aspects, they have a plan to come up with other solutions. For other aspects, they're still in discussion with the trade, including, as some members asked, whether there will be a drinking water safety law and so forth, and that is part of their considerations. But for other more concrete issues, they need to have more discussions, and they may not have concrete timetables for all aspects of the work anyway. But DS, maybe you can supplement. Okay, thank you, Chairman. In my reply to Dr. Nina Wong's question, I said that already. This time, why we are putting before you in particularly the amendment bill. We want to get this done first because right now, under the current ordinance, the way that it's written, give people the impression that the plumbing workers, when carrying out the works, they are already actually liable for an offense, because the law is written in such that the work has to be done by LP. So the writing itself makes the workers very worried, because it's not clear. If they're not LP and if they're doing water works, would they be liable for being prosecuted? Therefore, we see an urgency to make the amendment to make it clear that LP and also P workers, what are their responsibilities. So that's the main purpose of the amendment bill. It's not that we're not doing other aspects of the needed work. As I said just then, we will do all aspects of work at the same time, including looking into the safe drinking water law. But some works are easier and others are harder to do in a short period of time. So we'll just submit this amendment bill to you when it's ready first. It's not that we are not doing others. And also not, as Mr. Kwok just suggested, that we just get this done and then we'll put aside the whole thing. No. We actually can promise that once we're done with the amendment bill, we'll come back to Legislative at the next stage of our work, and you can see on the various aspects of the work shown in the PowerPoint, we will submit proposals to you for your scrutiny. So I hope that members can understand. It is a very complicated issue, particularly if you want to bring in new piece of legislation. It's really complicated. And for regulation of water parts, and it covers a wide scope of areas, so you can't get it done over time or just overnight, but I can promise that we will get the work done, and whatever progress we've got, we will come back to Legislative and explain to you what our plans are. Mr. Kwok, yes, I said it very clearly. Well, even I was having two meetings at the same time, but I know that you are here to explain to us the programs. Therefore, I asked you the timetable. I asked you very clearly, did you have a timetable? And secondly, in laying down the standards of drinking water, we've had the leaded water incident for 2 years now. It happened 2 years ago, and you don't have to invent any standard for safe drinking water. You don't need me to give you literature to show what should be the standard. So you have to set a standard and move towards reaching that standard. Whether you have an amendment or not, you can do that, and you should do that. And secondly, the Water Supplies Department, its own water inspection process, fails to examine or test for contaminations. It's shown by the latest incident, and you said that the whole process is very complicated, but you can give me a timetable still. And also, you can improve your administrative procedures. That's what you can do. You can set the standard. The government should be great at, you can ask people to do it in a voluntary manner, and then later on there will be legislation requiring for certain behaviors. At least you have to set the standard or the target first. So if you don't do the first step, so what's your standard? First of all, when can you give us your standard? And the Water Supplies Department examination of water, can its work be enhanced? Do you have a timetable when that can be done? Mr. Mack? Mr. Mack? Yes, just Mr. Kwok's views. Yes, we are aware of that. We are aware of your points. And we're still working hard on that. But today, I may not be able to give you concrete timetables of when we will finish the work concerned. But let me reiterate, we're not just trying to drag our feet. We have no such intention. We are working very hard. But if you ask me for a timetable, I can only say that we have a target. But whether we can reach it or not, we're talking about a lot of stakeholders here. We need to communicate with them and discuss issues with them. So therefore today I may not be able to make any promise here or give you any sort of specific timetable. I hope that members can understand. It's really complicated.
驗水嗰度係
What about tests? On many occasions, our department has already explained that after the lead in water incident, the Development Bureau commissioned an international expert, and we've also drawn reference to the practices around the world, and we've also taken into account local circumstances, whether the protocol that we're currently using are suitable. And I can tell you that work has almost been completed, and we're going to tie the loose ends very soon, and then we can give members a briefing. We're at the final stage of our work at the moment, so I'm afraid I cannot tell you at present anything more about our work, but please understand that we're towards the final stage of completing our work. I think that after the meeting you can give us another paper explaining this part of your work. As mentioned just now, this amendment relates to licensed plumbers, plumbing workers, their obligations and duties in the ordinance. In relation to the developer's role, are you going to submit another paper? Are you going to submit another amendment bill? Perhaps you can explain in your supplementary paper. Also, for the timetable, you may not have a concrete timetable in mind, but please let us know what is your target commission date. Let us know. Dr. Edward Yu. I think having heard comments from members, I know that they're all concerned with the timetable, or at least a roadmap, how you are going to implement the recommendations or requirements in the COI's report. I think that this view is consistent, but I do have other questions. In the industry, we have more and more prefabricated parts, including plumbing installations. Does it mean that this amendment bill does not cover the use of prefab materials? And also, if enforcement is only conducted by way of inspection, it will be very difficult to discover breaches, because from past experience, we know that it's very difficult to know whether the licensed plumber is involved. So, apart from rationalizing the concepts of designated trade, at least a project manager or the person in charge should have some information which designated persons have been authorized by the licensed plumber to carry out what part of the works, such that when an irregularity is discovered, then they can take the initiative to report the matter to the department. Otherwise, site inspection would entail a great cost for enforcement. So I want to know whether there is a better way to enforce the law. Also, in the law, there is a clear difference between plumbing works on fire service and also plumbing works on an inside service. I think we need to clarify that for various aspects of the works, such as alteration, maintenance, repair, you need to make it clear that maintenance and repair or alteration will be removed. And also, for the works can be carried out by a non-LP. I want to know how you can enforce this part of the provision. And about the transitional arrangement, I understand that there is no mentioning in your paper about that. That is to say, you have identified the breach, but then before the amendment takes effect, you will not enforce the law. Well, let me take the two questions. First, on prefab materials. If plumbing installation is also included in the prefab material, then the relevant requirements must be observed. After installing the prefabricated part on site, regardless of where the prefab materials are manufactured, they still need to observe the requirement. The question is how we can identify that, and I think the law is clear in this regard. The law covers all materials, including the materials used for the prefabricated component. For the licensed plumber, especially, we have this so-called responsible licensed plumber, and he has this obligation. He needs to make sure, by inspecting the materials used for the prefabricated component, that they are up to standard. And our idea for the future amendment bills are that they need to be professional. We will set out clearly the obligations and the criminal liability, and we are still thinking about these matters, which will be completed in the next phase. Whereas for today's amendment bill, the licensed plumber must ensure that the materials used in the prefab component are up to standard. As for the responsible person, as mentioned just now, and I'm referring to professionals, basically, they will also give it a thought, but not included in this amendment bill, right? Because as mentioned just now, for Section 15, at the moment, the way it is drafted seems to suggest that the workers could be breaking the law, and we'd like to first plug this loophole. Where for transitional arrangement, the bill also provides for transitional arrangements. Of course, after the bill comes into effect, the new requirements have to be observed. But before it comes into effect, the existing requirements will be followed. I think when it comes to the clause-by-clause scrutiny, I can further explore with the honourable member wording of the provisions. As for the fire service and inside service, again, when we come to the clause-by-clause stage, we can explain why it is drafted this way. Next, Mr. Leung Kwok Hong. Well, Chairman, in the past, plumbers belong to a specific trade, and plumbing works can only be done by someone who has gone through the relevant training. The first point is that I understand, because for the existing ordinance, non-licensed plumbers carrying out works will be breaking the law. It seems that it's problematic, and you need to relax the requirement. Now, my concern is this: prefabricated components. If you cannot check those, then what's the point? Or are you suggesting that you cannot do anything about prefabricated components that are not in compliance with the law? I asked you before, we have different manufacturing bases around the world, apart from China. So if you know full well that the contractor receiving this order is not using proper materials, and let's say if it's an UK manufacturing company, then of course the company will have to follow the relevant regulations in their own jurisdiction. But the point is, we're in no position to detect any irregularity. You're allowing them to use the prefabricated materials lawfully. But the problem is the materials may not be up to standard. And how are you going to protect our workers? Well, because for the lead-in-water incident, clearly something went wrong at the installation stage. Well, lead solder is the quickest way to join the pipes. And it is impossible to use mechanical compression to install pipes. So even at the design stage, you already had in mind that pipes should be joined by soldering. And when something goes wrong, you prosecute the workers, and you're encouraging people to break the law. I don't think even negative vetting is a problem, because you're authorizing the workers to do to carry out plumbing works, but you cannot guarantee the quality. It's fine by me. I understand that you're going to conduct inspections, but setting aside what may happen in the future, tell me what will happen now. Mr. Mack, well, thank you for giving me this opportunity to respond to the members' questions about the use of prefabricated components. Basically, after on-site installation of the prefabricated component, the fire services or the inside service, we need to make sure that each component will be compliant with the law. I think Mr. Leung also understands this. Please don't waste our time. Well, you were in the construction business, so was I. We know that the concrete used at the testing stage and the actual construction may be different. I also did it once. I just made the best brick possible. I can be very frank that when a test is needed, I would create a very nice brick for the first batch even. I think the key is how you're going to enforce it. What can be done to make sure that the irregularities can be prevented? I think, Chairman, you know very well. Well, I'm clear about that, but I can explain, since Mr. Leung asked, that the principle is that regardless of where the prefab component is manufactured, the law stipulates that if you're the person in charge or the responsible person, then you should be responsible. You can join pipes by mechanical compression or lead soldering. Never mind about that. But the ultimate test is to test the quality of water. Well, let me give you a suggestion then. The burden should be borne by those people. Say, you can set up a center for them to send samples for testing, and they also need to bear this burden and pay and to conduct tests at their own expense. It may be a harsh requirement, but they may complain otherwise. Say, if you have, say, a center to commemorate the lead in water incident, then you can receive samples from them and they can conduct tests at their own expense. Well, Chairman, please allow me to finish. Because for the responsible person, they can just make a declaration and do nothing else. But if they do that, then once an offense is committed, they will be in great trouble. So you can take a more relaxed approach, but then they may be liable for some serious troubles if they get caught. So that you can take a two-pronged approach. You post a burden on them for them to conduct tests at their own expense, and it's a neutral institute, or say a testing center. And then the industry can factor in the cost so that users, including the government and the public, can be reassured. And third point, since it is such a serious matter, you should set up a fund so that customers may be assisted to file claims, to exercise their rights. If you take this three-pronged approach, then there'll be little chance that something would go wrong because the burden will be shared among all parties.
Otherwise, disaster would happen. Now, anything happens, then you should have thorough checks. Okay, DS, would you like to respond to the proposals? Mr. Mack. Yeah, thank you, Mr. Leung. I think in our next stage of work, in the review of material control, we will consider Mr. Leung's suggestions. But today, let me also say a few words. Right now, the LP has to, in relation to the parts used, be responsible. But he's of a lower rank, much lower rank. The LP, how can he take such a heavy burden once he's got a job, but he's like a small subcontractor only? Same with Hong Kong-Macau-Zhuhai Bridge. You need to hold people at the top responsible. You need to have a clear system of rewards and penalties. It's like, in Asian battles, whoever wins a battle will be promoted. But you are actually asking the plumber to take all the burden. You understand that, therefore, in our PowerPoints, it's mentioned that our next stage of work will be on. Well, I think the trade has reflected to me and he has expressed their concern to me. You can't really ask someone at the bottom of the hierarchy to take all the responsibility. It would just cause people to take their own lives because of the heavy burden. Mr. Mack, please continue. Yes, I'd just like to respond here. At our next stage of work, we will look at the role of the contractors and the responsibilities that should be shouldered. That's really our next stage of work. We'll consider Mr. Leung's views. But right now, the LP have to be for the parts used in his project. He should be responsible for the parts. Whether they are prefabricated or not, he need to be responsible. And therefore, he has to, go to the places where the prefabricated parts are made to check that the standard materials are used. And when the project is finished, the Water Supplies Department has a final inspection mechanism. And because of the lead and water incident, the inspection mechanism has been enhanced. And it includes say for the use of heavy metals, there should be on-site inspection. And they also take water samples. Because if the part used is not up to standard, then in the water samples, we can find out whether that's true or not. The sector is aware of what they need to do, and of course, if they have found problematic parts and if they need to replace all the parts, then that will have a big impact on the entire project. And so I think right now there are enough deterrents. Next one, Helena Wong. Chairman, I think quite a number of members have expressed concern about, after the lead and water incident, what follow-up legislative work should be carried out to ensure that water is safe. We know that this amendment bill is just part of the work. It focuses on workers, but for the entire regulation of drinking water, you don't have it yet. So I propose that the administration should prepare a paper listing out the stages of work in relation to the areas mentioned in number 2 or page 2 of your PowerPoint in terms of regulation of contractors, suppliers, and so forth. So we have an overall view. Otherwise, I can't, as members, just look at this amendment alone, treat it as a standalone part, and then we move lots of CSAs to regulate workers alone. That would not work. So the government should give us a paper telling us what other work or aspects of work would you carry out, so we know the context. And then at least we can explain to workers what our next stages of work will be, and how it affects trade associations and so forth. So please give us the paper ASAP, so that our concern can be eased. And just as Mr. Mack mentioned, that the Development Bureau and WSD have talked to consultants and got their advice. You did that in March. So I hope that the consultants' report can also be submitted to this committee. Maybe there are good suggestions there in the report that should be incorporated into the amendment bill. So what sorts of advice were given by the consultants? Please let us know, and it will be good if you can give us a timetable as well. But on the whole, you need to have a rough time frame. Maybe say in 6 months you will do your work in relation to the trade associations, and what can be done in about a year's time. Of course, you can just give us a rough idea at least. I know you can't stick to very specific time frame, and you need to let us know the consultants' views as well. And Chairman, can you tell us, and the administration, please tell us, this amendment bill is not that long. It's not as thick as the columbarium bill. So by when do you think we should finish this clause-by-clause scrutiny? And you expect how many meetings we need to have to deal with, and also issues of concern to members? We need to set the agenda so we know how many more meetings are planned. Do we need to finish the whole thing before middle of July, or do we come back in October and then have this bill submitted to the council? So can you give us an idea of what we need to deal with? I hope that at the next meeting the administration can give us an overall view and give us the paper. We need to invite associations, individuals to express their views, right? So I know you will deal with that later on. I'm not going into detail on that, but can you give us the progress, the arrangements for meetings? Okay, for the first question, I think Again, we want the administration to give us papers, and it's really important to give us the papers. And for the holistic review proposed, if you can give us more details on the review, then you can help us with scrutinizing the amendment bill. It helps us more focused. Just stay focused on the core, or the outstanding issues. And also for members' concerns, if they want to, move any further amendments, they need to know the overall context first. So, Mr. Mack, you explained today and you reiterated the urgency of having the amendments done. But please give us a paper nonetheless to give us more comprehensive information. Members have asked for a roadmap, timetable. I'm sure you understand what we are asking for. So timetable and the consultants' reports. Mr. Mack. As Chairman just said, I think we will go back and try to write the paper to spell out our views on the way ahead so as to ease members' concern. We are sincere about really getting the work done and follow up on the Waterworks ordinance, and also to see how we can better improve the system. As for consultants' report, we have carried out various studies, so we'll see what studies have been completed, and then we'll provide members with what's available. Timetable. We do hope that, as I just said, we hope that within this electoral year, the amendment bill can be completed. But I know the time is really tight. And we also need to listen to the views of the sector. So if possible, we would propose that, we can meet more frequently. We can try to provide what you need. So it's mainly whether LegCo can arrange earlier meetings, and if so that we try to provide what you need. Is it necessary that we must finish the amendment bill in this LegCo year? I know it could be difficult, judging from the remaining time of the current LegCo term. But if we can't do it within this term, then we can wait till the next term. That's not unacceptable, but we'll try to. We hope that the scrutiny of the bill or the meetings of this committee can be held more frequently, so that even if we can't finish the bill, we can immediately finish it off at the start of the next LegCo term. So, okay, for members' consideration, if we were to resume second reading debate in the Council, the latest date would be July 12th. But if you want to resume second reading debate, then the House Committee, we need to finish our report on June 23rd, the latest. So if you think there's an urgency to finish the amendment bill, then we finish the amendment scrutiny to plug any loopholes in the amendments. I think we can move towards that target. Personally, I do hope that we can do it, but time is really tight. So maybe we can talk about now the date for the hearing, public hearing. The Secretariat in the paper proposed that June 19, a date of June 19, but they just checked the time slots. June 12, there's a time slot on June 12 as well, so we can meet 1 week earlier. I believe that members will be inclined towards having hearing from the sector and relevant individuals before we start the scrutiny, right? That would be very helpful to hear people's views. So I don't know whether officials can make it. or you can tell me whether June 12th, like 9 a.m. to 12:30 or 12:45, there'll be a room then. Can you make it on June 12th? Yes. Okay, June 12th, if that's okay with you, then on that day, from 9 to 12:30, would that be all right? I think we can spend half of the time on the public hearing, and then the remaining half will be reserved for scrutiny of the bill, the amendment bill. So, June 19th, we can still have another meeting. Then that means there'll be 2 more meetings coming up, and we'll see whether we can finish the scrutiny. That could be our target. Maybe we can see if it works. The public hearing will be on June 12th and June 19th. If there's room available, then we can have our meeting on June 19th. Would it be in the morning, June 19th? Yes, also in the morning. Yeah, there's a room available in the morning, because in the afternoon I have 2 meetings. So I won't be free in the afternoon. Yeah, it'll be in the morning. So public hearing in the morning of June 12th, and then June 19th, another meeting.
Fine by me. So if there is no problem with the administration, we can use this timetable as proposed. Deputy Chair, you're okay with that, Mr. Poon? Well, I think there is no alternative, but well, for these 2 dates, in fact, I have other meetings. I must dash between 2 meetings because it's also important to listen to the deputations. We still have some time, and I have another question. In relation to plumbing works on fire service and inside service, I think that for plumbing workers, for those carrying out plumbing works on fire service, they're different from the ones doing inside service. I suppose we're going to invite all the practitioners in the plumbing industry, including those for inside service and those for fire service. Thank you, Mr. Poon, for your suggestion. Now, we do not wish to change the scope of work of the workers involved, because, in short, for plumbing workers doing fire service, they can continue to do so. The same applies to inside service. We do not intend to change the scope of work through this amendment bill. Of course, on the 12th, when we invite the deputation to speak, we do not object if plumbing workers for fire service are also invited. About inviting stakeholders and deputations to give their views, the Secretariat will send invitations to the relevant organizations and other stakeholders. A notice will also be posted on the website of LegCo, and we have a proposed list of organizations to be invited prepared by the Secretariat. If you have other organizations in mind, please make your suggestions. I see that many of these organizations are actually trade associations or companies, and I think that we should invite representatives of plumbing workers as well. I see number 9, Hong Kong Licensed Plumbers Union Limited, and there is also another company called Licensed Plumbers Association Limited. We should invite them as well. Yes, and also we have professionals, scholars in the legal sector, etc., involved in the discussion of lead in water incident. I suggest that we invite them as well, and also experts and scholars in universities. I hope to listen to their comments as well. Yes, maybe you can you can submit your list to the Secretariat as soon as possible. Right, and also on the LegCo's website, you're going to invite interested members of the public to come as well. Yes, we're going to put this invitation on LegCo's website so that the public will also know about it as well. We welcome everyone to the public hearing. Another point, a think tank. I think that they also have members looking into safe drinking water legislation. All right, the meeting is supposed to be adjourned at 12:45. Well, Chair, how about since we're in a hurry, we should make good use of the time and start the discussion right away. No need to hurry. The meeting will be adjourned at 12:45. So let's proceed with the bill. Dr. Wong. A question about 15. It refers to what persons can carry out plumbing works, and one of the major amendments is that at present only licensed plumbers can carry out plumbing works, and then now you have designated categories A, B, C, D, licensed plumbers, registered plumbing workers, registered skilled workers on a temporary basis, and then point D, I'd like to ask a question on this. A person carries out specified plumbing works under the instruction and supervision of a licensed plumber or registered plumbing worker. And then E, a public officer authorized by the Water Authority, and that's about the government. My question is this. A person who carries out the specified plumbing works under the instruction and supervision of a licensed plumber or registered plumbing worker, what person are you referring to? Is any training required, or that can anyone do plumbing works under the instruction? Will some basic training be required? Any specification on the qualifications, whether the person should be an apprentice, whether the person has taken an IV course, or is it really just any person? Because if that is the case, I wonder if this is a loophole in the bill. Thank you, Dr. Wong, for your question. I think we should put it this way. At present, we have the designated workers for designated trade, and not about this piece of legislation, but the one that took effect on the 1st of April. Those carrying out plumbing works can come under 3 categories. First, skilled workers with the relevant skills, and also second category, semi-skilled workers, and also another category, that is workers who have yet to acquire the required standard of skills, and yet under instruction or supervision they can carry out the relevant works. Now, Dr. Wong just now asked what these people are. We just call them general workers. That is, they have not acquired any license, they have not completed the trade test, they have not reached the level of semi-skilled or skilled worker, and under such circumstances, such a person can only carry out works under the supervision or instruction of the so-called master. The skilled worker will have the responsibility of overseeing the work of the general worker. And we are aligning this bill with the requirement of special or designated workers for designated trade. Well, of course, we support that because by then we can pursue liability. We can find out if the person has received the relevant training for the designated trade. But you're now opening the back door. Somebody who is not a designated worker can carry out works in this designated trade. We also need to consider another factor, and that is to attract new blood to the industry. If only workers having acquired a certain level of skills can be allowed to work, then there may be a problem with attracting newcomers to the industry. In the industry, the practice is that general workers tend to follow certain masters, and when they reach certain level of skills, they can then apply for the trade test and then become skilled workers. We have this mechanism which allows new blood to join the industry. But at the same time, we attach importance to quality control. And that is why we need these people to carry out works under the supervision of their masters. And we also have guidelines explaining the responsibility of their masters. I understand that. I'm not against the idea of attracting new blood to the industry. Of course, we need that. And of course, they need to work under the supervision of the masters. But still, even for a general worker, he should receive some form of basic training. Can we just go out to the street and find whoever who is willing to carry out the works, even illegal workers? I think Mr. Mack can elaborate on this point, but the point is, we now have this arrangement under the designated workers for designated trade. There are workers who have yet to complete the trade test, and under supervision, they can still carry out the relevant works. Mr. Mack, yes, perhaps let me further elaborate about newcomers to the industry. Not all works involved in the plumbing installation require high level of skills. Some works may involve carrying of materials for, the more labor-intensive works. Then the skill level required may be different. We also need to consider this point. For the general skilled workers, under the supervision or instruction of skilled workers, they can still assist in the plumbing works. And responding to Dr. Wong's point, does it mean that no training at all is required? That's not true, because even for general workers, they first of all need to get a green card, that is, green card training. I understand that, Chairman. But I've been told by some plumbing workers that this is exactly their concern. The back door may be open for somebody who hasn't gone through any training at all, and in the end, causing the masters to be criminally liable. If you're talking about workers carrying materials for skilled workers, then they may not only be involved in plumbing installation, and I think you need to specify that. My concern is whether you're opening a back door, creating a loophole in the designated workers for designated trade arrangement. I understand members' concern. Our consideration is that the worker should be working under the supervision of a skilled worker who has knowledge, and that skilled worker would consider whether the person has gone through any training or has acquired any skills before arranging for the worker to carry out the works. For a newcomer to the industry, of course, he will not be taking up soldering work. But we're talking about some workers who have been in the trade for some time and have yet to gone through the trade test, and they should be given a chance to accumulate experience. So you're talking about apprentices. They have gone through training, but they have yet to pass the trade test. And you should specify that the person is somewhat an apprentice. I want to make clear that these workers may not have acquired or may not have passed the trade test. They may come with different level of skills. They might be a newcomer, or they might be in the industry as a general worker for some time. And for the skilled or semi-skilled worker supervising the work of these workers, their responsibility is to decide the work to be delegated to the workers based on their skills. We're not going to specify what a worker should or should not do, but we will provide guidelines to the skilled workers responsible for supervision, under what circumstances and how the supervision should be carried out. Say for a total freshman who wishes to learn about soldering, then the worker responsible for soldering must supervise the newcomer throughout the process. And there may be another worker who is familiar with the work but hasn't passed the trade test, and the level of supervision required may be different. We therefore will prepare guidelines to remind supervisors what they should do. We are, however, not specifying this in the provision of the bill, what he should do. The supervisor should be either a licensed plumber or registered plumbing worker. I don't think the situation as mentioned will arise. I don't think that since the supervisor will be criminally liable, he will be just looking for anyone to do the job.
So, Mr. Mack, maybe explain a bit in your paper. Okay, Chairman, do we have time? So we end at 12:45. Yeah, you can ask another question. 15A. 15A is about power of entry into non-domestic premises and power to question and so forth. So an authorized officer, well, I think it refers to people from the water supplies department, right, may at any reasonable time enter any non-domestic premises to ascertain whether specified plumbing works are being or have been carried out on the premises in contravention of Section 15. And the officer may also take photographs there to look at the surface. So that means it is like inspection at construction sites. And yeah, basically inspection of licenses. Yeah, and to see who are doing the work, whether they are specified persons. So my question is, you are talking about non-domestic premises, like uncompleted buildings. That is, you can have the inspection when these buildings are being constructed. So when the building is ready for occupation, and if before people move in and you carry out the inspection, but at that stage, what can you do? Is there not much you can do, Mr. Mack? I think the purpose is to ensure that when the construction is underway, there are appropriate, that is qualified, workers carrying out the works. So when the building is being occupied, then in theory, all the works and the inspections should have been done. So there will be no need for any entry into the premises for inspection of licenses. But if the premises are already occupied and if there are renovation works being done, then For renovation works during the period of that, if there's nobody living there, then the works consent and the premises will be considered as non-domestic, and then we have the power to enter for inspection because the works are underway. So under the amendment bill, we can send people in. But how about for buildings, renovation works, and if there are pipes to be replaced under the Operation Building Bright, for example, what will you do? Is there nothing you can do to regulate? I think our thinking is that we need to strike a balance. Of course, we do want to enter premises where construction is underway to make sure that people carrying out the works are qualified. But we also need to protect privacy of the people living there. So we don't want to have excessive powers, even that to the extent that we move into people's flats without a warrant or without a consent. So we have struck a balance here, and that, say, if there are people living there, or anywhere with people living there, then we won't enter the premises until we've got their consent. That is, the owners have to agree first. Would you really get the consent? Yes, we would. There are so many old buildings now due for repair, and the repair works and maintenance works that will involve changing of water pipes. So would you tell the watchman there to tell the security people there that you will enter in some premises to carry out inspections? Yes, we would contact the security people there, but we won't go to every single building. You do understand that because of limited manpower. But will definitely go to those buildings for inspection. This is very important because otherwise this bill will only be able to regulate new buildings, but not old private buildings, because that will be problematic. Yes, I think for non-domestic premises we won't enter. Even under the Operation Building Bright, there are still corridors which are not domestic, which are public areas, that under the amendment bill, our colleagues from WSD should be able to enter there. But for domestic premises, then we need to get owner's consent. It's not that you can't enter domestic premises. Chairman, why am I so concerned? Because around the world, in the most advanced regulation of safe drinking water, you wrote it. You need to tackle the issue at source, all the way to the water tap. That you need to look at it from the user's viewpoint. But Mr. Matt, you're saying that you will tackle it from source to the public pipes or corridors. But you need to do the work all the way, or ensure safety all the way to the water tap. Mr. Matt, I think it's very clear to you how we can ease the worries, how we can strike a balance. I believe that for household occupants, you don't want to see, officers coming into your flat any time because of renovation. So, and also, how do you define non-domestic premises? Well, for people living there, we wouldn't have the power to enter automatically, but we need to get the consent first. It's not that we don't have the chance to enter, but we need to get the consent first. How do we define the premises? We would use the idea of current use. Say, in a building, a new building under construction, when it's under construction, it's not yet a residential premise. So at that moment, when it's not a residential premise or domestic premise, then we can enter the site. Chairman, let me reiterate. The regulation of safe drinking water must be tackled at source, right from Dongjiang River or the reservoir, all the way, has to be monitored all the way through to the water drawn from the tap at home. If you say you don't want to cause nuisance to households, and then you will not enter the premises and not interfere with the water from the water tap, and that would be problematic. For people who've moved in to a premises, you need to have random checks. Mr. Mack, I agree with your concept that we should monitor from the source to the water tap all the way through, but the last step, say from public corridors to the domestic premises, we need to strike a balance between privacy and entering, the right to entering. We just don't want to stipulate in the ordinance in order to give us the power through the ordinance to enter. But I think all you need is the household's consent. You can't break in, of course, but as long as there's consent from the household, then you have to make sure that your regulation would not omit that step of entering the premises. And also for individual renovations of flats, if the people only do renovations at a few units, then would there be anyone monitoring that kind of work? But the pipes could be wrongly soldered, because we've still found in some industrial buildings using contaminated soldering materials. Even it's been 2 years since the Latin water incident, so please try to avoid any loopholes. So please let us know. Even for renovation at individual units, for large-scale maintenance and repair work, you can't just say privacy and you don't do anything, because otherwise you wouldn't be able to tackle the water contamination issue. Well, I think if there are wordings in the bill that says that any authorized officer can enter any premises at any time done at the public hearing, I think the residents would actually have an outcry. So how to strike a balance, Mr. Well, let me supplement here. Just then, in Section 15A, the term of non-domestic premises and the provision on entering those premises without a warrant. So it's for inspection. It's mainly for the purpose of inspection. But in Section 12, indeed, contains provision similar to Dr. Wong's concern, related to her concern. If we are carrying out inspection of anyone or any domestic premises, we do have the right to enter, but we need to get the owner's consent first. It's not that as long as there are people living there, we cannot do anything. No, we can carry out our work. There's a way for us to do our work, indeed. Section 12 is not amended, so therefore it's not mentioned in the paper, right? Yes, because there's no amendment to Section 12. Right now, we would use Section 12 to carry out the work in relation to renovation at domestic premises and premises where there are people or there are residents already. So we can use Section 12 to do our work. So Section 12, is it being enforced? Yes, it is. Yes. How do you enforce it? If we were to enter a premises, as I said, for inspection purposes, to check the works, to see if there are any irregularities, we will invoke Section 12. WSD can carry out surprise checks at the sites. So maybe you can provide the supplementary information in the paper, because that section is not amended, so we don't see it. Yeah, you need to let us know, yes, and tell us, your current practice. It's not that, you don't have the powers. It's not, but the reality is not exactly like what's mentioned in Section 15A. So you have more flexibility with non-domestic premises, but if it's a domestic premises, then you have to enforce your powers through Section 12. So please let us know in writing. For non-domestic premises, we would use Section 15A. For domestic purposes, we can invoke Section 12. Sorry, time's up. We only got 1 minute left, so please discuss it next time. Okay? So thank you all for attending. Our next meeting is scheduled for June 12, Monday, 9 a.m. We'll meet till 12:45. Meeting adjourned.
都得嘅，問啲啦，8點半。仲未答啊？哦。如果你未答咧，你就會留。哦，OK。仲有提政府代表咧，就法律顧問咧，我哋即係有啲信俾咗你，有啲問題就仲係等你哋答覆㗎，好嘛？咁盡快答覆。好，好，係冇錯。嗰日我哋定早啲啦，但係時間上預長啲啦，19號都。要偷少少時間啦。係，唔係傾唔到都唔緊，因為你就算我哋傾到咧，係咪大會處理到都難講。